Good morning, everyone. My name is Michelle Ward-Tackett, and I'm a mediator at the State Employment Relations Board. On behalf of Chairman Zimpher and the other board members, welcome to our third virtual forum. If you didn't have the opportunity to join us for the first two forums, they were recorded and are accessible from our website, just as this presentation will be in the near future. If you've previously joined us, you may notice that we are using Microsoft Teams live event versus regular Microsoft Teams. So some of the features operate a little differently. Recognizing that many of us are working from home, like I am today, which brings about unpredictable interruptions. So this platform automatically turns off your camera and your audio. Our first two forums focused on the negotiating and the mediation processes. So today we're shifting our focus to what happens after the negotiating parties have reached impasse and are headed to fact-finding. The topics will be presented in a point-counterpoint exchange, reflecting strategies from both the labor and management perspectives. To help us do a deep dive into the fact-finding preparation process, from selecting a fact finder to the hearing process and everything in between, we are fortunate to have two highly experienced practitioners in public sector collective bargaining. First, I'd like to introduce Susanna Muscovitz. She is currently a principal with the law firm of Muscovitz and Limmerbrock, LLC. She has been practicing labor and employment law since 1984. She's been an OSBA certified specialist in labor and employment law since 2002 and has received many accolades. She also serves as an arbitrator. Susanna will be presenting the union perspective in today's panel. Representing the management perspective will be Jonathan Downs. He is also an OSBA certified specialist in labor and employment law and is currently working for the law firm Zashin and Rich. Jonathan has negotiated more than 500 contracts in the last 30 years, most recently on behalf of the state of Ohio with its largest labor union, OCSEA, representing 27,000 state employees. Before the presentation begins, I would also like to introduce my fellow mediators, Ken Hickey and Chris Young, as well as Leisha Sapp and Justin Brown from our research and training sections. Without them, this forum would not be possible today. As I previously mentioned, the format for today will be a point-counterpoint exchange between our guest speakers. I will be asking them prepared questions and giving each party 3 to 5 minutes to respond. We welcome participation from the audience, so please feel free to ask questions at any time during the presentation by typing your question in the question and answer section. This is similar to the chat feature that most of us have used in these virtual platforms. Leisha will be monitoring that feature for us and present the question when appropriate. The prepared questions are available in the Q&A section if you want to follow along. We are also providing links to resources available on SERB's website that you may hear our speakers reference today. That, I'm going to start with Susanna first and get to our first question. So Susanna, your negotiating team looks like it's getting close to that impasse. So what are the pros and cons of fact finding, and under what circumstances would you recommend it?
Good morning. Good morning. First of all, I want to say I'm happy to be here, and before I answer that question, I just want, in case people that are watching this don't know, that SERB has a wealth of information on its website that you can download for free. They have guidebooks. One of the guidebooks that they have on their website is titled Fact Finding Guidebook, and it contains references to the Ohio Revised Code and the Ohio Administrative Code. It contains timelines and procedures, and it's very helpful, especially if fact-finding is new. So today, Jonathan and I are not going to go over those specific rules. We're not going to go into the details because that's information you can look up on your own. But what we're going to talk about really is our experience, our recommendations, and our advice on how the process works. So that's why the webinar, in fact, is called Insight in Fact-Finding in Today's Climate. So back to the pros and cons. Let me say that one of the things that I enjoy the most about representing labor unions, as opposed to representing individuals in employment matters, is that there's a relationship between the parties, and it's an ongoing relationship. So when you're negotiating a contract, it's a contract that both sides are going to have to live with. And you're going to have to live with it for anywhere from 1 to 3, more often 3 years. And it's likely not to be the last contract that is negotiated between the parties. And that's why, in many ways, the best contract is a contract that's arrived at directly at the table. And I will often tell my union clients that when the parties settle at the table and both sides walk away and they are both equally unhappy, that often is the sign that it really involved a true compromise. And it more likely than not will lead in the next round of negotiations to another settlement at the table. So when I think of fact finding, I think of it as part of the checks and balances process in the whole negotiation spectrum. So oftentimes the willingness to go to fact finding, the ability to go to fact finding, the preparation to go to fact finding results in a settlement. It results in the ability to avoid fact finding. But that being said, it's a very important step when the parties, for a multitude of reasons, are not able to reach an agreement at the table. So going back again to the pros and cons, when I think about fact finding involves risk. And one of the risks is that you could win issues that are not the most important. You can lose issues that are the most important. There's expense to going to fact finding. You might be incurring attorney fees if you're using an attorney. You might be incurring expert fees if you have a financial expert. And so when you're looking at the pros and cons, you want to weigh the decision and the fact that the decision might not be accepted by one or both parties versus the certainty of an agreement at the table. And this in some ways is especially true if your bargaining unit is a striking bargaining unit, because the next step, other than a settlement, would be a job action. And so the calculation is a little different if you're working with safety forces or a nurses unit or a unit that has the ability to go to conciliation. Now, sometimes this calculation is a very easy one, because when the issues on the table, are so unreasonable that it's a no-brainer to go to fact finding. So sometimes it's an easy one. But if the parties are not that far apart, and if you think there's a sense that they could come together with a reasonable compromise, then I think the risks of going to fact finding are outweighed by the certainty of a settlement that's reached directly by the parties at the table. So Jonathan, do you have any insight on that?
Good morning and thank you. And I would like to echo Susanna's comments. First of all, SERB for organizing this, SERB for the wealth of information that's out there. I won't repeat it, but it's all there. But I do need to do one other thing before we get started, which is to recognize the hat with the that Mr. Hickey has, to point out that there are more than one hat in this world. Just for everybody who knows me and knows Ken Hickey, this is the Virginia Tech. So with that comical point aside, we have our fun. We have our fun in mediation and in fact finding. And I point this out because one of the aspects, and Susanna is absolutely correct, it's best deal to get at the table, and to keep people's minds open as to what's going on. And this is utilized many times. It's centuries old. Is to inject a little humor so people begin to think a little bit. So away from that for just a minute. One of the downsides to fact finding, for those who wish to push it to fact finding, is I can get a little bit more. And there are certain bargaining units that, and we can name a few, but certain bargaining units will say, well, we'll just take it to fact finding, we can get a little more, which means that the party on the other side is going to hold back. If I know that that is the modus operandi of a bargaining agent on the other side, or a bargaining team on the other side, I'll hold back. Because then you have room to move when you get to the table. The risk Susanna talked about, the cost she talked about, the acceptance of a recommendation she discussed, and the strike versus conciliation unit we will get to in a couple minutes. One of the reasons for sometimes having the outsider is what they call in politics plausible deniability. So the decision or the recommendation is made by somebody other than those who are at the table. So if you need plausible deniability and you want to be able to blame somebody else, okay. To me, that's difficulty in terms of what's there in terms of the fact finding. We've seen upticks in fact finding whenever there's been a recession, whenever there's been a pandemic, past the early days when there was a lot of fact finding. Maturation occurs. One of the pros about going to fact finding, though, if you have a new team, is that they have to walk through and they have to see what the process is about. They have to be able to identify the information that supports their position. They have to identify what and when they're going to present. We'll talk about some of that in one of the later questions. But the fact finding is sometimes a cleansing process for people. It's an opportunity to say their piece, to get in front of the neutral, to talk to the arbitrator, to have their opportunity to have, quote, as they say, their day in court. So there's sometimes where there is a cleansing aspect to it. At those points in time, I caution clients constantly be careful. Don't get upset by the rhetoric. That's an advocate speaking, but it also allows you to see from the outside in what others see of you as well. So there's some mirror effects here as well that I think are important. That's you get to see yourself as well. I've had many times, I'm sure Susanna said this as well, where we go through the presentation and then we settle. Because then we'll talk about the shifting between mediation and fact finding and back and forth. But most times for my side of the table, it is important for them to see and hear what's happening in the process. And it's important for them to hear what the advocate on the other side has to say so that they learn their strengths and weaknesses as well. And that's, that's any litigation, including and most importantly for us in the fact finding. So the circumstances, more pointedly, Shelley, to your question, is I look to fact finding when it appears that we're at an impasse at the table and people are just talking past each other and repeating themselves. So fact finding at that point in time, I think, becomes more important. And in the last year, I can tell you I've had 3 or 4 situations just like that, where in other times without a pandemic, we might have settled at the table. We might have resolved things, but there were points when I have to draw that conclusion as an advocate and as a representative, not to drag out the negotiations, because negotiations is like a trench process. During every negotiation session, people will just dig their trench a little bit deeper. And then that does not help. I like people to be up on the field, in the flat land, on the level playing field, looking at each other and talking through the issues in an open way. And that to me is the important thing. That many times the pro to fact finding is it flushes out positions and people's positions on those, and the con is that people use it as an excuse for somebody else to blame. Thank you, Shelley.
Thank you. So I'm going to stick with you, Jonathan, in our next question. So whether it's through a MAD or you've submitted a request to SERB to go to fact finding, you got a list of fact finders. What factors do you consider when choosing a fact finder?
First and foremost, for me, it's temperament. Do we have the person who has the temperament for this kind of bargaining unit? In police and fire, service workers, teachers, universities, there's a different approach. So I want to make sure that the fact finders that are on the list are acceptable. And I want to make sure that if I have an economic situation, I have someone who understands budgets. And in the last year, that's been extraordinarily important. What is a budget? If I have an issue that is legal centric, like contract interpretation or issues or language to make changes, that there'll be somebody there who knows what language is and what it means. And when I'm looking at temperament, I'm also looking at someone who has a balance between private and public sector. I think that both are myopic in their views sometimes, where I can only be an arbitrator in the private sector or only a fact finder in the public sector. So I want people to not be burdened by a history of having just one path that they've looked down before, because I explain to clients it's our job to educate the fact finder, the arbitrator in every situation. If it's a situation where I believe there's a strong likelihood that the parties can still come to an agreement, I want, as I call, the two hats arbitrator. I want someone who has the ability to wear a mediator hat and an arbitrator hat, making the decision, or fact finder hat. I want someone to be able to take that hat off and on. And there are a number of them out there who they put on the mediator hat, they sit down, they talk to the parties like a mediator, and they press parties for this and that. And then they take that hat off and they go over and almost forget what was said over in the mediation session, which I think is a critical factor for that person, and then make a recommendation based on what's presented to them. There are some arbitrators who do not mediate, and if I have one of those and it's a situation where I think we have to go to a hearing, we have to have that situation, I will probably lean more toward that person, simply because I want a considered opinion. So I look at that. I look at their history, and they don't have to have a deep history of being an arbitrator or fact finder, but they have to show or demonstrate an understanding of organizations, of contract issues, of economic issues, etc. So I look to find that. And I also look for diversity, because I believe that's something that's extremely important in the public sector for employees. I'm looking for someone who's going to bring a broader opinion, and it's not diversity in the sense of race, sex, age, national origin. It's diversity in the sense of all of those, and diverse understanding of labor and management as well. Thank you, Shelley.
Susanna, you have something to add?
Well, I would like to say that if you listen, I'll push back a little on what Jonathan says. It is not a situation where there's 100 names and you get your own choice of who the fact finder is, okay? So when it comes time to go to fact finder, first of all, the parties can agree on anyone that's on the CERB list, just so you know, but it has to be a mutual agreement. But if you request a list of fact finders from CERB, you'll only get 5 names.
Right.
So you are picking someone most often from among those 5 names, and that means you get 2 strikes. And so there's a multitude of factors, but there's a limited choice when you're weighing those factors. I also want to let folks in the audience know that fact-finding decisions are published, and you can go to the CERB website and you can look up a particular fact finder, and you can look at all of the decisions that he or she has done since, I think, 2012, so it's a long time. And you can look at, well, this person doesn't have a single published decision, or this person has done 20 cases. So you have a sense, you can figure out whether or not the individual has a lot of experience, whether the person has done a lot of cases with safety forces or not done, or school teachers, or whatever the group is that you're representing. And one other thing, Shelley mentioned a MAD, which is a mutually agreed dispute resolution procedure. It's a mouthful, but there's a statutory process in 4117 where at the negotiations table, step 1 is mediation, step 2 is fact finding, step 3 is either a strike or conciliation, depending on the bargaining unit. And a MAD is the ability in the statute to do something different as long as it's done mutually between the parties. So you can change the fact finding process. You can change the timelines. You can even skip fact finding in some cases and go directly to conciliation, which is a similar process, but is binding. And I just want to let people in the audience know that there are a lot of options, but the key to making these differences, or doing something that's a little bit different, is it has to be mutual. It can't happen by one party over the objections of the other party. It has to be done collectively.
Okay, great. The only thing I would add to that is when CERB does send that list of 5 names, we are providing a background sheet that shows the industry and the credentials of that particular fact finder to assist in that selection process. So Susanna, you mentioned the statutory process. So the next question is, what are the statutory time limits for fact finding, and how do they relate to a G11 or a retro waiver? We might want to talk about what that is in case people don't know.
What we call, I guess in the industry, a G11 or a retro waiver is relevant to safety forces, to bargaining units that are non-striking by statute, which mostly is law enforcement officers and firefighters, but dispatchers, corrections officers, and others. But putting that aside for just a minute, the statutory time limits for fact finding are very, very strict. So either party, you don't need agreement on this, can request a list of fact finders through the Bureau of Mediation at CERB by just asking, sending an email, and you'll get a list with 5 fact finders or 5 potential fact finders, and you'll get their bios. And from the time you get your list, there's a deadline in making a selection. You're required to make a selection within that deadline, and you can select someone not on the list, but again, the selection has to be mutual. And if the other side does have the ability to say, I'm not picking, or I'm not picking off the list, or I don't like the list, and CERB will appoint somebody, and that person is guaranteed not to be one of those 5 individuals. Now, from the date the fact finder is appointed, the fact finder is required by statute to hold a hearing and render a decision in 14 days. That is a very tight time limit. And some people think, well, this is automatically waived or this is automatically extended. And I want everybody listening to know that is not automatically waived and it is not automatically extended. And anyone on their own, any party on their own has the ability to enforce that 14-day time limit. Now, there's a lot of reasons to extend it. Maybe you're not prepared. But if you are prepared and the other side is not prepared, strategically it may give you an advantage because you can push the hearing and the award much more quickly. And so you have to look at it in some ways like a chess game. I mean, it's a strategy decision. It might affect the relationship or the long-term relationship between the parties. But on the other hand, that's what happens at the bargaining table. So you've got this very strict timeline, and it can only be extended if you're allowing it to be extended. There may be neutrals that say, I can't do that within that time frame. CERB will give you a neutral who can, because that is your absolute right. Now, there's a provision in 4117 when you go to conciliation, which is under 14G11, that says that a conciliator, which is a binding process, cannot issue a financial decision within the same fiscal year that the individual, in the next fiscal year from when the person was appointed. And so, let me explain this better. First of all, you have to figure out what's your fiscal year. Most cities have a fiscal year that's a calendar year, but it's not 100% of the time the case. And so what that means is that you have to go through fact finding, assuming one or both sides rejects it. You have to then proceed to conciliation and select the conciliator and have that person appointed before December 31, or you lose not just retroactivity, but the ability for any wage increase at all in the entire next calendar year. Because of that situation, because of that problem or that risk, which is a really big deal for safety forces, both sides will often sign what's called a waiver to that, which says the conciliator could issue an award, for example, this year that goes back to January 1, 2021. So the reason that this is relevant is that if you are representing safety forces and it's October and it's getting into November 1 and you want to go to fact finding, you have the ability to say, we're going to fact finding. We're not waiving the statutory 14-day limit. We're going to force you to have a hearing and get an award within a very short time frame unless you sign this G11 waiver, because it allows the parties more time to really address the issues at the table. And it allows the negotiations to be more, I would say, natural, or for the parties to have the opportunity to have more in-depth dialogue and hopefully and often to actually reach an agreement. But that's your hammer to an employer that refuses to sign that waiver. Your hammer is to force the process prematurely in many ways, but you need to be prepared and you need to be willing to go to fact finding very quickly in order for that to happen.
So, Shelley.
Yes.
I think it's really important to point out that process and strategy, the presentation today, we're talking a lot of process and strategy. So I hope people, process this through their minds. So I'll pick up the G11 point for just a minute because I do a lot of safety forces negotiations. And I like your word hammer, Susanna, because it goes both ways. This is a dual-headed hammer. If I have a union rep who's not prepared, if I have a union rep who doesn't want to move forward, that just wants to kick it past December 25th because he's on vacation somewhere or she's on vacation somewhere in December, then fine, I'm there as well. So the question then becomes, how is that perceived if there is a G11 or there isn't a G11 in the timelines? The timelines at CERB are unrealistic. I spoke to that in 1983 when the bill was in the legislature. Yes, I go back that far. And that they're unrealistic, and the G11, in my opinion, is also an unrealistic provision because it is used as a hammer as opposed to working matters out at the table. It is taken as a guarantee of retroactivity. Well, effective dates of wage increases is a negotiable item. And because some arbitrators also perceive it as a guarantee of retroactivity, it makes employers hold back on economic issues. So it has a negative effect in the negotiations across the board. So believe me when I tell you that hammer has two heads on it. Susanna, I appreciate the timeline because it's important for people to understand that these things don't happen in 14 days. I can't tell you that I can remember of a situation where any union rep on the other side of the table from me pushed for the 14-day hearing. All right. In reality, it doesn't happen in good labor relations. I'm not going to press someone for the 14 days. I'm not going to hold that hammer over their head because I want the parties to have a resolution at the table. And if a fact finder feels compelled to issue his report in the 7 days, which the statute requires, then you're most likely not going to get a very good report. It's going to be very cryptic, and that's going to make its recommendation. It's going to go from there. So one of the key problems with the G11 is the mindset in the minds of some union reps that it's a guarantee of retroactivity. And the mindset of some arbitrators who have bought into that, which I as you can tell, I really disagree. That being said, if you as an employer representative are presented with a retroactivity or a G11 agreement, be very careful what you write because everything is negotiable in the G11 as well. For instance, making sure the conciliator knows that he or she can pick a date other than the beginning of the fiscal year. Making sure that the conciliator understands that they can fashion an award going outside the single issue aspect of it. And Shelley, I think it's sometime in the future. It's not for today, but aspects of what's in the conciliation process are important because that's another step for those in safety forces as well. So that's what I have to say about G11s. I think they're an impediment to negotiations. I think that the parties need to have serious discussions about what the alternatives are to a G11 before anybody signs one. But I think that it should not become your roadblock to negotiating a contract. What's our next question?
All right. Well, first, before I get to the next question, Jonathan, I hope it's not rude, but I just wanted to point it out that I was in 10th grade in 1984. So.
You're very rude.
All right. Yes, I'm no spring chicken. So when I had the opportunity to do that, I had to take it. So I'm sure you can appreciate that.
But, this is a profession where, because it's something new all the time, it is a constantly challenging, never boring operation. I mean, look how it's done for the octogenarian mediator that you have.
All right, with that, I'm going to move on to the next question.
Shelley, we had a couple questions, if that's
okay.
So one is directed to Susanna. She was talking about the conciliator, and they asked if they could have clarification about the inability of a conciliator to give certain awards during a fiscal year.
Sure, let me answer that. So if you look at the language, I'll actually quote it in section 14G11. It says that a conciliator may not issue an award that involves, and this is the quote, increases in rates of compensation and other matters with cost implications awarded by the conciliator may be effective only at the start of the fiscal year next commencing after the date of the final offer settlement award. This is wordy. So provided that if a new fiscal year has commenced since the issuance of the board order to submit to a final offer settlement procedure, the awarded increases may be retroactive to the commencement of the new fiscal year, end quote. So that's a mouthful, but let me break it down a little. Last fall, we're looking at November of 2020. I was in negotiations with a bargaining unit of firefighters. We had a few meetings, but really we're still needing, I think, a lot more dialogue. We proceeded to fact finding, and the management rep refused to sign a G11 waiver. And I said, I'm going to fact finding, and we're going to go to fact finding literally next week, and we're going to have an award in 14 days. And he flipped out, and I didn't care, because look, either we're going to be able to have a reasoned conversation, or I'm going to push this through, because we on our side, we're ready. What that meant was that if we just continued on and January fell and we went to fact finding and the fact finder's award was rejected by either side or both, when we went to conciliation, and that would have been, let's say, February of 2021, the conciliator would have had no authority to issue a wage increase at all during the entire 2021 calendar year. That's a big deal. That's a huge disadvantage to my client. So I'm not gonna put them in that position. So we're either gonna push it through, even if it's a bad award, I don't care. We're gonna reject it. We're gonna go to conciliation, and we're gonna explain to the conciliator, this is why we're in this situation. It is not an ideal situation. Okay. But it's because the other side was refusing to give us the opportunity to have more in-depth conversations. I am not going to lose all of 2021. Now, I also have made the argument that this includes any increase that the employer wants in health insurance, because it works both ways. It's any finances in either direction. I have not litigated that. I have not seen served case law on that, but that's how I read the statute. But what I'm saying is either we lose all of 2021 automatically, the conciliator doesn't even have the option, or we have more normal negotiations. That's what that language means.
Did that take care of the questions, Leisha?
Yeah, it does. There's one that's talking about conciliation, but I'll hold that towards the end when you guys talk about that.
Okay. All right, great. So let's keep going down this path. You've got your fact finders selected. And so let's talk about preparing your approach for fact finding. So I'm going to start with you, Jonathan. What are the most common sources of information, evidence, and factors of influence?
First, let me say I'm going to try to hit bullet points more than in long descriptions. We are almost over 30 minutes into a 90-minute, and we're on question 4 of 17. So I think we need to walk through this. And I would point out Susanna's explanation about conciliation is extremely important for those in safety forces, but there's a lot of considerations in there, more than 90 minutes would be able to cover. So if you're in that area, make sure you study it and learn it. The approach of preparing for fact finding starts when you finish a contract. My approach for fact finding is to tell the client, get a copy of the contract, electronic or hard copy, whichever, and begin to make your notes, begin to gather your information. So preparing for fact finding, my source of information, first of all, is how has this contract been administered? Did it meet up to the expectations and the projections that you had from the last round of negotiations or fact finding? So I think the document itself is one of my first resources. Secondly, if we have any economics in this, or even if we don't have a lot of economics in this round of negotiations, I want a presentation from the budget person as to the economics or the financial situation in that particular jurisdiction. Evidence then is I start gathering what are trends on the particular issues that are at the table. I'm looking at trends from fact findings, conciliations, from settlements and other contract negotiations, which means that even though I have a list of 5, which was mentioned earlier by speakers, we have deep benches of people that we all go to. Those of us who are in the business know we have a deep bench of people that we can go to and ask questions about and find out more about particular fact finders who are on that panel of 5 or alternate mutuals. Evidence is gathered beginning, as I said, the day you finish the previous contract, and I always go back to all the proposals and issues and the presentations made in previous negotiations, whether or not there was fact finding. Factors of influence, I'm looking to what those factors are. For instance, if there's economic issues, if it's a minimum manning clause, if it's health insurance, etc. I will tell you that one of the most valuable things that I have received from CERB in terms of resolving issues at the table is the health insurance report. The annual report is vibrant. There's 1 million data points in that thing. And when I lay that down in front of negotiators, many times we resolve the health insurance issue. We'll talk about impacts of issues later on. So I'm looking at the CERB, and I think one of the major mistakes made by negotiators is not putting your information on the table to begin with, not putting it on during negotiations, because I don't like, and arbitrators don't like, the gotcha routine in fact finding. And if you're holding it back, I'm going to say to you, first off, we never saw that in negotiations, Madam Arbitrator. They never laid that information back on the table for us to see. So getting resolution or also finding out where those disputes are. So common source of information, CERB, knowledge of the market, knowledge of what's going on in the world in terms of economic data. Office of Budget Management is one of the places I turn to for economic data. I look for Department of Taxation. I look to the Department of Development. I look for the demographics. So a lot of what I also lay out is the demographics, and I will address that a little bit more when we talk about ability to pay question as well. And those are my points on question number 4, Shelley.
Great. Susanna.
Let me just add that internal comparables, external comparables, bargaining history, meaning, what has happened over the last maybe 10, 12 years. And again, I'm going to go back to some of the information on that CERB produces, which I think is very valuable. You've got prior fact-finding and conciliation reports. You've got quarterly statistics. They come out with a wage settlement report. So what is happening around the state, and it's broken down by sectors and by geographical regions. There's a healthcare report that comes out every year, and again, it's broken down by regions and by sectors. And they have these clearinghouse reports. So if you want the wage agreements or the wages for all county, for all sheriff's deputies, or for all corrections officers, or for all municipal employees within Northeast Ohio, you can request that stuff.
Okay, great. So we've mentioned wages a lot in our conversation already today. So Susanna, what are the most common topics other than wages that you see going to fact finding?
I think the non-economic, well, the issues, when I think of wages, let me say I think of core economics. So I will include in that with wages, with health insurance. I think it's very difficult to resolve one without the other if health insurance is an issue. And with that, I also think duration, sort of wages, health insurance, and duration are sort of three legs to a stool. But other issues that will often go to fact finding are the hours and the working conditions that people have to address. And it depends a little bit on the sector. So for example, with firefighters, the golden work week, reducing the hours in a work week is often a significant issue. With law enforcement officers, a lot of times it's shifts or it's job assignments or bidding or even internal investigations. With school teachers, we're often addressing class size. We're addressing unassigned time. With nurses, we're looking at staffing issues. I also think that I have on a number of occasions gone to fact finding on issues such as layoffs, work jurisdiction, discipline procedure. How long can discipline be kept in your file, or what are your rights prior to discipline? And finally, subcontracting and work jurisdiction, depending upon the sector, can be very significant issues. So these really fall in the category of hours and working conditions, and those are issues that can be presented to a fact finder. Anything to add, Jonathan?
I think Susanna's done a great job of checking off. It's very contract and personality specific to the employer. Class size may be an issue in one jurisdiction, but not in another jurisdiction. Hours of work, that's almost universal. Time off, more pay, less work. It's interestingly enough, the wage increases sometimes are traded off for more time off, which then, as an employer, you need to calculate what the expense is for that time off. Comp time, the myth that comp time saves an employer money always comes up. More comp time banks, less time off, and so regularity and scheduling. One of it gets down to, I will tell you that there is no specific issue that's common right now to me, and in my experience, other than time off, time away from work. The shared work issue came up. That was a one and done issue. The remote work, we are seeing that. It was a major issue in the state contract negotiations, and it became days of discussion about shared work for the 16,000 employees working remotely. The contract speaks for itself as to what's not in there, because that's more of a gradual change. So staffing, manpower, layoffs, yes, once in a while. I haven't seen that very often, not lately, but time off and buried costs. I think the investigations, Susanna, I think that's going to be one that's going to be very important for law enforcement coming up, continuing to come up. What's the investigation process? Because there's external pressures on those as well. So everyone needs to be cognizant of those. And for those working in law enforcement, you've got to work out some mutuality in that as well. There's got to be some understanding of where that's going. So it's as wide as it is long, Shelley, in that area. So that's what I have to say on question number, what is that? Number 5.
Yep. So no, great point. I think you're absolutely right on the law enforcement piece. So let's move on. I'm going to stick with you, Jonathan, on question 6. So you've got your fact finder picked, you've got your date set. So in your opinion, how extensive should your fact-finding position statement be?
So I'll do a little bit of the process. The fact-finding statement's due the day before, which is unfortunate because I think that first of all, the parties aren't forced into acknowledging what their positions are, and the arbitrator's not forced to reading it before. I think it's really unfortunate where arbitrators walk in to day of a fact-finding hearing and have read nothing about the case. So our approach to it, first of all, is the timing. I want to make sure that our fact-finding statement, our position statement, is provided to and known to the arbitrator 3 to 5, maybe even 7 days in advance. I have some colleagues on the other side of the table who agree with that, and we acknowledge we're going to send it to them 7 days ahead, and we're going to mutually ask the fact finder to read it before he gets to the hearing, so he or she can walk in with the questions. The position statement for fact finding should be enough to educate the arbitrator as to what's happened, where are we, and where do we want to be. We talk about the tentative agreements, something that all fact finders want to know, and something as parties want them to know where they've given up things or they have received benefits in contrast. I also provide information to the arbitrator about the employer and the unit and the union, meaning the union there. I mean, what is this unit like? What have they had before? Have they gone impasse in the past? What are those fact-finding reports in the past? I'll also throw out and put in very specifically, and we'll talk about this a little bit later, but I will include the specific language that we're looking for. And that's where you get into when you talk about position statements. I don't like rhetoric in a position statement in fact finding. They're great for arbitration. So we will keep rhetoric to a minimum because it's just like, and Shelley, I'm sure you watched this on late night television, just like Dragnet, just the facts, ma'am. So we want to make sure that the fact finder has all those facts, and then we tell a story about the negotiations. One of the key things is for the professor, and you remember him, Susanna, Professor Younger from Case. We want people to see the big picture. I want the arbitrator not to make decisions on issues in isolation of the big picture, because we're painting a landscape here. We're not painting a fruit bowl. We're painting a landscape in this situation. So we're going to talk about what's happened in negotiations in the past round negotiations, what the tentative agreements are, provide copies of those, and what's really interesting now with drop boxes and arbitrators able to open up a drop box, many times we will also submit a number of our exhibits with our fact-finding statement or make reference to there being exhibit that supports this particular point. So we will provide a discussion. Others want to do the bare minimum. I think I think it hurts the process. I think it hurts the parties from being able to get to a resolution, which we'll talk about what you deal with when when the fact finder walks in the door. So extensive, that's how extensive we do it.
All right, Susanna.
I would say that what you want to do is find that sweet spot between saying too much and saying too little, because one of the things to keep in mind is that the fact finder is going to listen to the evidence, is going to walk away with all of the exhibits, and is going to walk away with his or her notes. But then at the end of the day, they're also going to have your position statement. And so they're going to read it not only before the hearing, but they're going to read it before they write the award. So you don't want to bog them down with too much, but you don't want it to be too brief. You want to be able to use it, as part of the argument. It's a persuasive process, and so you're trying to convince the neutral of your side. So just keep in mind that that's something that's going to be read not only before the hearing, but it's going to be read right before that person writes their award. And to reiterate, under the law, it does not have to be presented until the day before. I personally have had this happen, but I think it's a huge mistake when the other side puts positions in their fact-finding position statement, and we get it the day before, and it's something that was never presented at the table because they're nervous. All of a sudden they thought, oh my God, I've only been offering 001, and now I've got fact-finding, and I'm going to look foolish. And so they put money on the table, but they don't even offer it on the table. So your position statement should, in my opinion, also reflect where you were at the table. Sometimes people go the other way, but I mean, it should reflect where you are at the table. And in terms of the deadline of the day before, and I see there's one question in the chat about could these issues be changed, you know, the time limits in the statute. I will say that from 1984, actually the law was passed in 1983. From that day to today, the law has not been opened up, and both sides, I think, are fearful of what would happen in the event that occurred. Obviously, there were some major changes when we had the whole Senate Bill 5 issue, and that got reined in and wiped out. But I think that the law as written is not perfect, but it's worked pretty well since 1984. And anytime there have been flaws in the timelines, like the fact finder, like the position statement, the parties have been able to generally work around them by agreeing to exchange position statements a week ahead of time. I've done that many times. And so that's really why I think I'm hoping the law does not change, because I think it works. I think it works well. And I think the flaws that are contained in the statute are relatively minor. So.
Great. I'm going to stick with you, Susanna, on the subject of position statements. What's your approach in framing the issues for your position statements? And do you use actual contract language for your proposals?
I always use actual contract language. I am very, I have a very strong opinion that where the comma goes can affect the meaning of a sentence. You know, I think contract language is huge. The only time that you don't have to necessarily have contract language is if you are not changing any words. So if you've got a wage scale and you're looking at a 222, you don't have to necessarily do the math. You can say 222. Or if you have a provision where you want to change the uniform allowance from $750 to $950, no, the language will be the same. But anytime a sentence changes, anytime, even if you're changing he to he, she, you know, he/she, or even if you're changing employer to city, there can be a substantive part of that. I always use contract language. I personally use contract language in my proposals at the table and in my fact-finding position statement, because again, it affects the meaning. And one of the worst things in the world is when you reach an agreement and then you're drafting the contract and then you have a disagreement on how the sentence is worded, having already reached an agreement. You do not want to be in a position where you're arguing, because you have no clout. You have no, you know, there's no place to go if you can't figure out the language after an agreement is reached. Now, I will say one thing about how you split the issues. A fact finder has the ability to issue a recommended award that is not the same as what either side has projected. So for example, on wages, if the union wants a 3% increase and the employer is offering a 1% increase, a fact finder can recommend 2%. At conciliation, they do not have that authority unless the parties want to waive that. You're either going to end up with 3 or 1. And so the strategy is different because the risk is higher. When I go to fact finding, how I split the issues, if it's a safety force bargaining unit, I'm thinking ahead to conciliation, because the conciliator has to issue an award, either win or lose, but it's issue by issue. So how you split up your issues is also a substantive decision. And I will make that decision, first of all, at the bargaining table right away, and also at fact finding, because I want to keep the same designation about how you split the issues, both in my position statement and hopefully in the award that gets issued by the fact finding in the event the parties go to conciliation.
Anything to add, Jonathan?
Susanna and I agree wholeheartedly. I don't want the fact finder writing the language, period.
Right.
That has created more problems in the past than any other issue. What I will also indicate is the strategy on issue split that Susanna spoke to, which is what I call cherry picking. There are many times there are issues which are intertwined, and because one party tries to identify it as a separate issue, that becomes conflict between the issues if the fact finder, conciliator recommends or awards one versus the other. So I don't like, and I find it to be somewhat counterproductive to getting a resolution at the table or even in fact finding. And many times has led to the rejection of a fact finder, where you issue split out something as a specific issue because of this paragraph in this article, and you set it aside as a specific issue, but yet you ignore in your presentation the rest of the article. It's part of the whole. And one of the things about issue splitting, and Susanna is very correct, that is an absolute imperative on the part of parties when they're presenting it. How do we frame the issue is extremely important. It goes in any advocacy that we have, let alone fact finding conciliation. But what I will say, and I will emphasize, issue splitting creates conflict. It creates conflict in the language of the contract. It creates conflict at the table, and it's counterproductive to getting a resolution during the process. I will sign off particular sections of an article so that we can narrow down what the issue is, but I want the arbitrator to see what the parties agreed to in that article. If we agreed, there's 10 sections in it, and we've agreed to make some changes in 4 of the sections. We've agreed to make no change in 5 of the sections, but there's only one section of that article. Is that the issue, or is the article the issue? I need that arbitrator to see the whole, not the minute, minuscule portion that's at issue, because it's been taken out of context. So issue by issue, many times, for those of you who have to deal with this on the other side, it is your responsibility to educate, getting back to the big picture concept. You have to educate the arbitrators what the big picture is. So issue by issue is how conciliators have to award, but they need to have education and be identified as to what the full package is. So when I present language, I will present the entire article or the entire subject matter within the article. So if it's compensatory time, I want them to see how they earn overtime that garners a compensatory time, not just whether or not it should be 100 or 80 or 120 hours of comp time. I think that's, again, it's having them focus on one little thing as opposed to understanding how it works across the board. So actual contract language, absolutely imperative, but all of it, not just the item that's currently in dispute. That's all I have to say on number 7.
All right, great points from both of you. So you've been negotiating, you most likely went to mediation already before fact finding, and then you show up on the day of fact finding and the fact finder wants to mediate. Do you want the fact finder to mediate? Why or why not? And I go to you, Susanna, first.
I would say most of the time the answer is yes, okay? But there are times, and when you might want to think about, you can mediate and not necessarily mediate at the very beginning. So for example, you can mediate at the beginning before any testimony and evidence is presented. You can also mediate at the middle, and you can mediate at the end. And I have done all 3. So there may be times when, you've got a financial expert and the employer has the city finance director or the school board treasurer or, whomever, they've got a financial person and they're there and they've got their PowerPoint and they want to say their piece. So you want to say, okay, let's spend a half a day and listen to the financial presentations and then let's mediate. And sometimes that creates an impetus to both sides to have some kind of a reality check because they've now heard about finances from both perspectives. Also, I think early on, Jonathan made a comment that the parties sometimes want an opportunity to say their piece. I think that's true. And so I have actually had times where we want to put on our evidence, but we'll promise to only take a half a day or a shorter period of time. And then, you give individuals an opportunity to say their piece. And then people feel better about having the neutral hear them. You know, people want to be heard. They have issues that are really important and they're valid and they're critical to their work life. And then after that, you know, after that opportunity is presented to both sides, the parties may be in a better mind frame to mediate, and also the mediator himself or herself will be more educated. But that being said, even if you're mediating at the beginning, it's an invaluable opportunity to educate the neutral. And you can say things that you may not be able to say directly at the table when you're in fact finding. You can talk about, let me explain to you the personality situation. Let me explain to you why this is such a big issue for us. Let me explain to you why this is such a big issue for the employer. So you have an opportunity to educate, and in doing so to persuade the fact finder in a neutral, you know, I mean, not a neutral, but in sort of an off the record way of the of your side, of your position, of why you should win these issues. You also have an opportunity to explain to the neutral, these two things, okay, they're on the table, but we don't care that much about them. But this one issue, this is huge. This is huge. We are going to reject anything. I'm just letting you know, if we don't get number one, but number 2 and 3, not so critical. So it gives you sort of this ability off the record to educate the fact finder. And also, it's not uncommon to settle, because the fact finder is a person who's going to write an award. So if they have a different amount of clout than a mediator, no offense to mediators, but I mean, they are in a different position because they're writing an award to convince one side or the other, you know, you're probably not going to do so well on this issue. You might want to think about a compromise and issuing something that makes sense. So I think it's a good process. There are times when the circumstances are such that I do not want to mediate, but I'd say that's more the exception than the rule.
Anything to add, Jonathan?
I echo everything that Susanna has said in this situation. I would sum it up by simply saying that it's mediation with a fact finder. It is the same as mediation with a CERB mediator, and you get the special time to spend with Ken Hickey. How much better can it be? But think about what you do in mediation when you're mediating with a fact finder, with the understanding and the realization that the fact finder is going to write an award, a recommendation, I'm sorry, which brings me to the second part, which is that, and Susanna and I'm sure you've done this as well as before, a mediated award, which the fact finder says, well, the parties say to the fact finder, well, this is what we can agree to, but we need you to write it. So the strategy there is for both sides. Do you need to have it said by someone from the outside for political reasons, small p political reasons? And from a union side, a union rep is going to say many times, I need a mediated award because if I take it back, I'm not going to give 50%. But if I have to approve this, but if I have to have a 60% to reject it, which is what the rejection of fact finding requires, back to the statutory process, then it's harder to reject something than it is to accept something. So you just look at the negative. The way the statute was written is that you have to take a negative act. You have to say no to something. Now, a lot of people like to say no, but from a technical standpoint, that's what it is. But from a reality standpoint, we've worked out mediated settlements, mediated awards or recommendations, which then you have that tight time frame of 7 days to either accept or reject it. And it is a steadfast rule. There are no exceptions to that. It's 7 calendar days from the date of issuance. And you have to have a 60% vote, which means you have to get there, you have to get a decision, and you have to get it done. So, and also allows, you know, for someone like Susanna and I to work out the specific language, if it's something that's going to be a language issue, that we can say, here's the language that we'd like you to work out, to put into your recommendation, so that we both know what it means going future. Because one of the things that I believe we both strive for is to make it so that it's not open to interpretation, so that we're not back there in an arbitration on interpretation of language. So very important for economics, but I think more important for the way language reads when you're having a mediated fact-finding recommendation.
All right, great. So I'm going to stick with you, Jonathan, and go to the next question. How do you present the finances in order to address the ability to pay issue?
That is a loaded question, has been from the day one. What does the phrase ability to pay, and is it an inability to pay? It's open to interpretation. Again, this is one of the things that was written when the AFL-CIO wrote the Collective Bargaining Act in 1983, that was not defined at that point in time. So Suzanne and I can agree on some things on the statute. I'm not going to agree that there doesn't need to be some clarification. Almost no fact-finding conciliation awards on this point. For those of you who've been around long enough, there was a Wayne County case a number of years ago where someone was accused of ability to pay. I think you have to look at, and this is where I get into demographic information. The ability to pay is not just how much money is in the treasury of that particular jurisdiction. I heard one union finance expert say that if a city had $1 in its carryover balance, it could afford a pay raise. That's ludicrous. And I really appreciate that, because if you're looking at the data, and some of the outside analysts look only at a CAFR, which I challenge many of you to even tell me what CAFR means in the acronym, and they don't look at the ability to pay. One of the most persuasive arguments that I've had in front of arbitrators is, what are the demographics? What is the ability of this jurisdiction to raise money, so therefore to pay people? So if I have a number of times presented this, I've got a middle class jurisdiction that doesn't have the ability to raise taxes because they're already taxed themselves higher than those comparable external comparable jurisdictions that the union rep is going to bring to the table. I have explanations about the tax. Where does the tax come from? Right now, sales tax is king, income tax is in question, and property tax are static, but maybe going up with home values. So when we're looking at the ability to pay, it's not just what's in the budget. It's what is the makeup here? What has the trend been? What has the carryover balances been? And what have been the costs? So when I look at that, also, one of the things that I point out is, what are the total compensation criteria for each of these individuals on the other side of the table? How much? It's not just what's in their paycheck. It's not just what their leave time is, but it's a combination of it. What is the compensation package? And I'll roll back to what we talked about a moment ago, the health insurance. One of the most vibrant points in the health insurance report that CERB has is how much each party pays. How much does health insurance cost the jurisdiction? How much does the employee have at stake in that? And even if health insurance is not on the table, that is going to be part of the presentation that I make, because it is a major cost aspect, and everybody has a stake in that game. Because my statement is very simply this: for every dollar that's paid in health insurance premiums by the city, county, township, whatever, is one less dollar available for wage increases, because there's a finite pool of money available. Then you get into the balancing between the various aspects of the city, police and fire and service. If you're in a city, teachers not so much, because they make up the bulk of the costs, and it's going to be different in counties versus cities. So when I'm looking at ability to pay, again, it's the big picture. And going back for a moment to the fact-finding statement, typically that's where we will make the explanation to the neutral. Here's what this city, county, township, school board is all about. We want you to understand what's here. And getting back to the basic question of who do you pick as a fact finder, I want someone who can read a balance sheet. Thank you, Shelley.
Great. Susanna, I'm sure you have some thoughts on this topic.
Well, I want everyone to know that the statute does not say ability to pay. The statute says ability to finance. And those are different concepts. So the ability to finance is, could they pay this, not do they have this in their checkbook? And so I think it's very important to constantly remind fact finders that that's really the statutory criteria, because I hear ability to pay all the time. And I think it's important to say to whenever it comes up, it's not the ability to pay, it's the ability to finance. And so, for example, is the employer billing, ambulance runs the way they are supposed to? Are they collecting the way they are supposed to? Delinquent tax revenues? Are they making decisions that discount or that take away how much they have that they could affirm, that they could collect more? That's relevant when you're looking at ability to finance. So I just want to add that caveat.
Good point.
All right, sticking with you, Susanna, is there much difference in presenting non-economic issues versus economic?
I think
And
there is.
Susanna, can I break in for a second and add a audience question before you respond?
Certainly.
We had someone asked specifically in law enforcement sectors, have you experienced anything in fact finding or conciliation with management talking about softening seniority rights?
Oh, yes. Especially when I say seniority rights, I see that as a fight when it comes to things like job bidding and shift bidding, well, especially job bidding. So, for example, specialty units, and the larger the law enforcement agency, the more units are out there. So a small city might just have the detective bureau, but a larger city, they might have 15 different specialty units doing all kinds of things. And so who gets, who is assigned to, the evidence unit, or who is assigned to, particular specialty? Is this a seniority-based decision, or is it the chief's discretion? So definitely I see that is a mandatory subject of bargaining. And I think that you want to look at language in terms of how you select, what you do. Are there time limits involved, and how much of it is based on seniority, and how much of it is based on maybe the chief's discretion? So the answer is yes, that is an issue. So putting that aside, going back to presenting non-economic issues, I would say the presentation is very different, because it's not really spreadsheets, it's more storytelling. And oftentimes at a fact-finding hearing, what I will do is I will present the background information as to why this is important, but I'd like to have either a member of the negotiating committee or a member of the bargaining unit explain real life scenarios. Why does this matter? I think it's very persuasive to listen to somebody say, this is why this is important. And this has been particularly important in the last year with COVID. If you're, when I'm dealing with teachers that are working in a virtual forum or this hybrid forum, or police and fire that have been working through the whole pandemic, especially firefighters that are working with COVID positive patients in the back of an ambulance, transporting people back and forth to the hospital, to have somebody say to a neutral, this is what it's been like to go to work every day. This is the risk. This is the fear. This is what it's like when I worry about bringing something home to my family. I find that very persuasive in explaining why some of these non-economic proposals are so critical that we're actually bringing them to fact finding. So yes, I think that bringing it home and personalizing the issue to the day-to-day work life of members of the bargaining unit can be very persuasive.
Jonathan.
I'm going to blend 10 and 11 together real quick here, because
I think that's a good idea.
I think Susanna and I just did that, and I appreciate that very much. Non-economic issues have to be explained by somebody, period. Because it's an operational issue, or for the employer, it's an impact issue. One of the key things about the non-economic issues, though, that I find, we hear the stories, understand them, remote work, et cetera, in the back of a box, et cetera, is for the employer to constantly remind the arbitrator, fact finder, that they're there because of the public. Yes, it has an effect and impact on employees. Yes, it has an effect and impact on corrections officers who are in a prison face-to-face, corrections officers in the jail face-to-face with prisoners they have to be with. COVID is a reality of the work life in some places, unfortunately, a reality in the work life in some places. So we have to deal with more than just the effect and impact on the individual. We need to look for resolutions and how to get around that. But the key thing is for someone on the employer side to step up and say, yes, however, this is how it affects and impacts. It raises the costs. It dilutes the ability of the public employer to provide services. And, you know, if we're going back to ability to finance, remember who does the financing? It's the taxpayers. The ability to finance is all driven by the ability to convince them to increase the taxes, if that's what we're looking at, to increase the tax base. So when I'm looking at this, I like to tell the whole story. But from an operational standpoint, and we get to seniority as an example. For instance, someone wants to be on A shift, B shift, or C shift, or day, night, or day, afternoon, or night. A police chief is going to tell you he needs experienced or she needs experienced people on the afternoon shift where most of the activity is. The older officers are going to say, I earned it, seniority is, et cetera, et cetera. You get the gist. So the effect and impact on the operations, the ability to be efficient and effective is extremely important. And obviously being cognizant and aware of the impact of it, that it is on the individual employees, because you have to recruit employees to be in there. Anybody in law enforcement knows today how hard it is to recruit people. COVID, you know, the pressure being put on law enforcement, and being sued, sovereign immunity. So there's a number of things why we need to have, you know, be cognizant to the individual's ability to recruit and retain, and money is not going to be the answer there. In my opinion, it's going to take a lot more than just money. The resources are what they are. Let me just slide right on into witness testimony. I think we both have covered the expert witness testimony. I don't think there's an expert that can talk about the effect and impact of language which affects the operation other than the people who are there. Experts that I have used traditionally have been non-existent. I use people who are there who understand the finances, who understand the effect and impact. Occasionally, I have brought people in who are health insurance folks to talk about the effect and impact, but thankfully, unions and reps and management folks are much more educated about health insurance than they were 20 years ago. It is not the fight that it once was 20 years ago. Suzanne, I don't know about you, but we rarely take that issue to impasse in fact finding or conciliation. So the expert witnesses, occasionally I'll use it for manpower allocations, for a Me Too provision, for especially for minimum manning clauses. We'll need someone to talk about it from an expert's situation, but it's more rare than it is common to bring an expert witness in. You should be able to have someone internally speak to the issue in a cognitive way that they can identify that. So is witness testimony required? Typically not, unless it's a very technical issue. And that's what I have to say on that. Susanna, I'm anxious to hear what you have to say.
I don't use expert witnesses on anything other than a financial expert, somebody that can analyze the finances of the employer. But other than that, I would think it's very rare that either side ever brings in an expert.
All right, great. I'm going to move along here, and I might modify the last couple questions here. Are you guys good to hang around a little bit longer? We're about 10 minutes before our end date or end time.
Certainly.
All right. So I know in mediation for me, a lot of the federal relief surrounding COVID has come up in negotiations. So I'm going to ask you to address that, Susanna, how the pandemic Or has the pandemic affected the ability of parties to reach an agreement? And if those federal packages like the CARES Act, Family First Coronavirus Response Act, or the American Rescue Plan Act have had an impact?
So this year, I would say I've had more situations where the parties have agreed on a very short extension to try to get through the pandemic. And that's for a lot of reasons, partly because they're just, you know, they just don't have the capacity. But I also have, we're negotiating, and parties are going to fact finding, and they're going to conciliation, and they're settling. So that's not always the case. And I think it's, you know, and I don't buy the argument that I get constantly from management that there's all this uncertainty. There might be some uncertainty. There's always a little uncertainty, but there's also a huge amount of money out there. If you go back and look at how much a city, a school district, an employer is getting from the CARES Act from last fall, from the American Rescue Plan Act, which is the one that was passed recently, or even from the refunds that are out there from the Ohio BWC, they are enormous. They are enormous. Now, the arguments I get is that this is one-time money. And so I have seen contracts that have had a bonus that's not in the base, but that's over and above an across-the-board wage increase. So the last couple contracts that I settled had a pretty significant bonus, but they also were on top of 2%, 2.5% wage increases. So it's not a substitute, but I think, yeah, the availability of money does affect the wages, and I think it's absolutely deserved. These are people that are literally on the front lines and are critical to what, you know, to what's happening. I personally am able to be in my office. I'm able to work remotely. We're doing this webinar remotely, but my clients don't have that luxury. And so I think it's well deserved.
On both sides, you know, what money is where is always the question. It didn't take a pandemic to figure that out. We had the same thing in the recession. We've had it, you know, I've lived through more than one recession, and not as big as the Great Recession by a stretch, but I've been through a number of recessions. So I think one of the key things that came out of this, and for a lot of reps that I work with, is the realization about the uncertainties in the financial pictures. The more seasoned reps, you know, looked at this and said, okay, so where's the money? Because one of the problems that management has is not explaining what is there or not there. You know, are there carryovers? Where's this money? So we spend a lot of time going back again to sources of information. What is the source of the revenue stream, breaking it down to its component parts? No one doubts, you know, aside from, you know, this is not the rhetorical statement. It's no one doubts that everyone who's working in the public sector that's in the front line has some exposure. No one doubts that. You know, I mean, the entire public understands it, management understands it. And I don't think that, you know, it's one of the things that it can be weighed in when you're looking at a wage increase or you're looking at a pandemic. Every firefighter, police officer, their lives are on the line regardless of whether or not it's a pandemic. Teachers are dealing with students regardless of whether or not it's a pandemic. This is just another situation that we have to deal with. It's big, much bigger, but it's also provided for wonderful opportunities for people to look at how things work, how they don't work, making changes. I'm excited to see the amount of things that are going to come out of this. The effect of the negotiating table, let me use just real quick the example, the state contract negotiations. 52 people at the negotiating table, 30 days of negotiations and mediation, settled at the table through mediation, every day, every minute, every second, virtual. Yes, it had an effect and impact on how we operated, and we worked through it. It took longer because it was all virtual. We worked through it. Do I prefer it? No. Smaller jurisdictions, I want to get back to the table because I believe we can get the resolution more rapidly, but I will give you that example. 26 people on each side of the virtual table. That screens full of faces looking at you is the same as sitting at a table. Has it been different at the table? Yeah, because getting back to the issue about the money, we have to explain as management, and it's your responsibility as management to explain how you're going to use this money. How does it work to the effect, the impact? What have you done? What infrastructure? What have you made? What purchases have you made for the protection of the employees, the PPE, et cetera, et cetera. So to me, it's become a major issue and the effect and impact. It has made management and employees more, shall I say, versatile, being able to make those changes. We saw very, very few grievances coming out of changing work schedules, changing who works together. I mean, people, I think the pandemic demonstrated to us how people, when they sit down, they're dealt an issue that's outside of their control, how they address it. We had precious few grievances during the shutdowns, and we've had very few coming out of that. There's a couple notables, but it's not been the panacea of arbitration cases for lawyers or the Full Employment Act. In fact, I think we spent more time educating than we did litigating through that entire period. The processes and the inherent technology here is fantastic. You know, I now take my laptop, thank God for that, take my laptop and type up proposals and spin it around at the table and show the other party. We can make more moves quicker on our feet with the technology that's out there. And one of the other key things I think it's important for people to remember, going back to an issue that we both discussed earlier, seniority. We have a multi-generational workforce. This is exciting because they bring a lot of different ideas and thoughts to the process, but they also bring a few, shall we say, challenges to how people work together, and it becomes a responsibility on both sides to listen and hear and understand. So the multi-generational workforce has had a dynamic impact on management, the delivery of services, and our union organizations as well, as I have seen. That takes me through question 14, just trying to wrap through a couple points together there, Shelley. So,
no, I appreciate that, Jonathan. I was going to ask Susanna if she wanted to add anything regarding the topics of 13 and 14, which are pandemic and virtual processes.
I will say that in my experience, I'm still dealing with a lot of employers that really do not get it and are not, I think, they do give lip service to the fact that, well, we understand that you're on the front line. We understand, but we don't have any money. I'm sorry. And so I actually don't buy the fact that employers are, I mean, there are some employers that really have stepped up to the plate and have worked with the employees in terms of what are your needs, but there are employers out there that I've dealt with that walk all over people. So it is not universal in terms of working with people, and I think it's a shame, and I think it reveals sort of an attitude that people might be expendable. But let me say real quickly that with respect to technology, negotiations and fact-finding is a people business. And so I look forward to being back in person at the table, whether it's at negotiations. I think that the virtual format works, but it's absolutely inferior. And it is not the same as being able to work directly with people in the room, talking through the issues and hopefully resolving problems. And that's what this is all about. So thank you, Shelley.
Great, thank you. Do we want to do any of the questions in the chat, Leisha, or?
Let's see. We did have one that just popped up. I haven't had a chance to look at it yet.
All right, while you're looking at that, I'm going to ask Jonathan the question of, tell me about a time you've been surprised by a Fact Finders Award.
The biggest surprise is when they write something that neither party thought about, and they tried to be the creative individual. Surprises, you know, after a while, we learn not to be surprised in this business, but deal with what they come down with. So some of the biggest surprises have always come out of, to me, that that they write something that was not presented to them because they're trying to be the mediator and overseer in some respects. Otherwise, winning an issue, not winning an issue, prevailing an issue, not prevailing an issue, that's going to happen. Probably the biggest surprise to me was very early in my career with one of the arbitrators emeritus, that he awarded the employer every position. And then, there are other fact findings where it goes the other way. So to me, I think the key thing is I would be surprised if you are surprised. And I try to explain that to clients as well. You've got to expect that this is a process that is not entirely predictable. We're going to try to make it predictable, but again, the only time I'm surprised is when they write something that nobody thought about and nobody put on the table and nobody spoke about it when we were in the process.
Susanna.
I think that's true. I think that when neutrals want to be creative and come up with something on their own, it usually backfires. And then you don't have bargaining history. You have problems down the road with interpreting it. It lends itself to grievances. And so the parties might not land on a certain position for a reason. And they're really in the best position to judge what language they want, what language they don't want. So I would agree that when a neutral comes up with something that's not presented because they think they're being creative, more often than not, it's a mistake. And I think that even though there may be an urge to do that, I think it is not something that should be encouraged.
All right, I'm going to move on to the next question. Is there any, to you, Susanna, is there any difference in how you approach implementing a negotiated contract compared to a fact-finding award that the parties accepted?
I don't know if there's a real difference between those two, but again, this goes back to the need to have actual contract language. Otherwise, what will happen is you don't want a fact finder's award that has ambiguity in it. And I have seen that where the rationale, the discussion sounds like it's going in one direction, and then there's a award that goes in the other direction. And I know he's not on the screen, but Jonathan laughing, because I think we've all experienced this, where you're reading it and you think, well, I'm going to win this issue or I'm going to lose this issue. And then suddenly they land somewhere else, but the award is the award where they landed. And if they explain their position, but they don't really put contract language in, it creates all kinds of headaches. So that's worse than when you're settling at the table and hopefully you have actual language and both sides initial it. So there's no ambiguity on where the comma goes, how the sentence ends, how the wording is. That's much more, it's much more stable. It's a much better process.
Jonathan.
Agreed.
All right.
You won't hear that very often either, by the way.
Yeah, I know. I'm not even sure what to do with that. I'll go ahead and, well, I think we have some questions in the chat, right, Leisha?
Yeah, we have a few questions in the chat. I'm just going to run through them and then let you guys cue in then on them. So we have Jonathan, this one's directed towards you. From an employer perspective, how do you discuss, yes, we have some money, but decisions need to be made around huge capital improvement projects with that money? We also have one that's directed more towards Susanna of how do you respond to the employer's claim of uncertainty in years 2 and 3 of proposed contracts? Mm-hmm. And then the last one is, can any of the federal assistance provided to employers be used by workers towards negotiations for compensation?
I'll just run the capital improvements. It's responsibility of management to explain why they're spending money where. To the union, the same as they do to the public. So if you've got a capital improvements issue, and I'm dealing with this currently in one set of negotiations, it's to explain what needs to be done and why. Because the reaction is by the public, they'll pass a levy to pave roads with a specific provision that says this is not to be used for wages. So if you don't listen to what's being said, the reaction by the public is going to be specificity of how that money is to be spent, because the infrastructure of a city is what developers look to, what organizations, industries look to determine whether or not they want to locate or stay or leave a particular jurisdiction. The uncertainty, again, we get back to projections, you get back to what we're looking at in terms of revenue stream. What is the source of the money? What is the viability of that source of money? And Susanna rattled off a number of items, which go back to your notes and check those. In terms of one-time money being used for pay raises, I think that is not the way to manage an organization, because you look at things like the estate tax a number of years ago, the death tax was taken away, made huge changes in organizations because you had the public pushback on taxes. So one of the things you have to be careful of, as the old saying goes, be careful what you ask for. Susanna.
I would say, and I'm going to look, actually, I'm looking at the next question, which is this whole issue of uncertainty. And I get this all the time. I've got money today, but I don't know what's going to happen in years 2 and 3. Part of the way to look at that is this something that they say all the time? Is this kind of a, deja vu all over again? Because there are employers that are constantly claiming uncertainty, and now they're saying it based on the pandemic, but they've been saying this for years. And I think when you can establish that, it goes against it, it takes the weight off of that argument, because there's not any more uncertainty this year than there's been in the last many years. And that's really the way to combat that. On the other hand, if there's a levy that's going to be on the ballot this November and you're negotiating in August, there is uncertainty and you want that money. So you might want to do a wage reopener because you know that levy is on the ballot. So the question becomes, is there real uncertainty, and is it something that's in a fairly short time frame, something that's going to make a big difference with respect to the ability to finance a wage proposal or another economic proposals? Or is it just sort of the same argument that you hear over and over again, that we don't know what we're doing? Which I think, the argument is you've heard this over and over again, and this is part of the job of any employer, is to be able to project out more than 1 year. So I hope that answers the question.
I think there was one last one there about using, can any of the federal assistance provided to employers be used to workers toward negotiation for compensation?
The answer is yes.
Don't quite agree with that, because it's money that it's one time. I don't know that you want to use it toward compensation unless you're backfilling a budget deficit. And we get back to, what are those projections and the uncertainty issue? There are a number of points to be able to respond to that. If you get to that at the table of management, there's a number of solid explanations for those forecasts. But I don't see one-time money as being the basis for wage increases or other continuing expenses, because I just think it's not good public economic policy. I just don't think it's good public policy. But that being said, I don't make the public policy. I advocate the public policy. The individual employers are the ones who have to make the determination.
So let me just wrap up and say that's a strategy decision about whether or not it should be used for wages, but the question whether or not it can be used for wages is a yes. So with that, I really appreciate the opportunity to sort of provide at least my insight and experience on this whole process of fact-finding.
How about you, Jonathan? Any last closing comments?
I greatly appreciate this. I think what you heard today is opposite sides, which is fantastic, because everyone learns and you need to understand the issues, because if you understand how the other side approaches an issue, you're going to be better able to resolve issues at the table. and good, efficient government organizations and good, efficient government services are what your jobs are all about. Suzanne and I are advocates, but I believe that I work for the public because when I work for an entity, I'm working for you. And the last thing I just have to say is the Virginia Tech. Thank you for your time, your patience, and your work. Greatly appreciate it.
I think Jonathan's forgetting what state he's in today. So anyway, you know, one thing I wanted to add on the federal assistance that I recently saw in mediation before I conclude. I saw a large county, and I don't know what program they use, but they had, at the beginning of the pandemic, had implemented cost savings days, and as part of negotiations, they did reimburse employees with some of that federal money they got on top of the negotiated raises. So just throwing that out there as things that are happening. So, wow, we learned a lot of information today. I think our speakers were fantastic. So I want to thank both Susanna and Jonathan for just sharing a wealth of information with us today. And of course, we want to thank all of you out there that hung around for an extra 15 minutes and joined us. So as a reminder, this forum will be made available in the near future on our website. You can also check out the many other resources and reference information that we have available through SERB via our website or by request. We hope to see you soon in person in the future. So until then, stay safe.
Thank you.
Thank you.
Thank you.